Hello and welcome to Counterpoint. I'm your guest host, Michelle Simard, and today I want to discuss an important story that was recently reported in the August 19th edition of the National Post. Columnist Rupa Subramanya wrote a story entitled How Ottawa Exploited Our Fear to Limit Our Liberties. In this article, Ms. Subramanya claims that Trudeau's travel mandates had less to do with science and medicine and a lot to do with politics and electoral gain. Her thesis is mostly based on testimony that was heard from a Federal Court of Canada application lawsuit, which was garnered by the cross-examination of several bureaucrats in charge of COVID recovery. The lawyer who extrapolated that testimony, Sam Presvelos, is here with us today to discuss the case brought on by two of his entrepreneurial clients, Carl Harrison and Sean Richard. Welcome, Sam, and thank you for coming on the show.
Good afternoon. Thank you very much for having me.
So every court case starts out with a story, Sam. Can you tell us the story of how this lawsuit came and why you decided to take it?
Absolutely. So, this lawsuit deals with just two ordinary Canadians who want to do what so many Canadians do on a constant basis, which is travel. Each of them have their own reasons for traveling, but they overlap. They want to see family. They both have elderly parents in the UK. One of my clients in particular needs to travel frequently for his business. And so in August of 2021, when Prime Minister Trudeau announced that individuals who are not vaccinated could no longer access federally regulated transportation system, well, that meant that they could no longer travel to see their families and they could no longer travel for work. And that was not an acceptable, outcome for my clients who have very legitimate reasons to want to leave the country. And even if they didn't have very legitimate reasons for wanting to leave the country, they should be entitled to leave the country at their will. And it was on that basis that they decided to, challenge the Prime Minister's mandate, challenge the policy and the rationale behind it. And that's exactly what they did. And as for the reason why I took it on, as you and I have spoken about, I'm not particularly a constitutional expert or a public law lawyer, but I thought that the mandate went a little bit too far. And I see an individual sense of responsibility as a lawyer living within a democratic society to use my skills and sort of, balance or try to address some sort of a rebalance of where we are right now with this policy. And I thought this policy was too much of the extreme. And so my clients connected with me. They asked whether I'd be interested in representing them on this very important challenge. And that's exactly what I've done.
Yeah, so essentially you felt the mandates were overreaching. And given the nature of what you do as a lawyer, regardless if that was your expertise or not, you felt that you owed it to yourself and others to challenge it. And when you got approached, you took it. So that's great. I'm sure your clients are very happy. But as I mentioned in the opener, this is an application and type of lawsuit. So can you explain to our viewers what's an application and why you chose this legal route?
Sure. So ordinarily, a constitutional challenge would be brought by way of an application. Sometimes it could be brought by way of an action, but an action would take a far longer time for us to get this matter in front of the court. And in the context of, my client's specific circumstances, Mr. Rickard, for example, has a father in the UK who has advanced Alzheimer's. And so we really wanted to choose a method that would proceed as expeditiously as possible, because in his case, we don't know when his father is going to pass. And we did not necessarily want to go with an action that might involve a lot more steps, a longer runway to get this important matter in front of a court and to get a decision that would hopefully strike down the travel mandates, which we thought were unconstitutional. And so that's the basis on which we proceeded by way of an application rather than an action. I mean, procedurally, there are obviously very important differences between the two. The primary difference is that in an application, you don't have live testimony. So my clients do not testify in front of a judge, as you might see on TV. The experts do not testify in front of a judge. They provide testimony through what's called an affidavit, which is an opportunity for them to provide their story as a sworn statement. They get cross-examined on it, but they get cross-examined out of court. But the transcripts are then used in court. So it's largely a paper-based record, so that by the time we show up for the hearing and the Attorney General shows up for the hearing, it's largely going to be read from evidence that's already in a paper record in front of a judge.
Great, thank you, because I think that's very, very helpful for many of our viewers, because when they hear lawsuit, like you said, everybody thinks about something that they see on television and they expect that back and forth. But what I do find interesting is the fact that the testimony that you received during the cross-examination, because an affidavit, it was a written affidavit, And then at that point, you then get to cross-examine a person live, like you said, not in a courtroom, but in a private office where you can answer these questions. And I do want to talk about that, and I want to talk about the details about that, because that's what's really important. And that was, I guess, the crux of Ms. Subramania's article. It was based on the testimony that you received. So that being said, we're just going to take our break, and we're going to come back, and I really want to hear all these details.
Sure.
Welcome back. As we were talking about before, this case is multifaceted, and you garnered a lot of relevant testimony, which I would like to discuss. So can you please explain to the viewers the major legal issues that are in this case so people can understand it?
Absolutely. So the travel mandates, it's actually not a law that's passed by Parliament. It was an executive decision that was made by the Minister of Transportation. And these mandates were enacted in 2021 without the input of Parliament generally. So these were effectively unilateral government decisions. And we challenged the government decision by way of a judicial review. And we're challenging them on the basis that they're not compliant with the Canadian Charter of Rights and Freedom. In other words, they're unconstitutional. And they're unconstitutional because they overtly restrict a person's Section 6 rights, which is your mobility right to travel, both within the country and outside of Canada. And they're not saved by Section 1. And we say that because we don't believe that the scientific rationale or the public health rationale was strong enough to justify suspending the mobility rights of unvaccinated Canadians.
Okay. Thank you. But I think our viewers need just a little bit, unpacking there, because you mentioned Section 1. And so, for all our viewers, Section 1 is part of the Constitution where our rights in our Constitution are guaranteed, but they're not absolute. And if a government is to infringe upon them, they may do so, but there's a test that has to be applied to govern and warrant why the infringement would happen. And that test is the Oakes test based on Section 1. So can you tell us a little bit about this test and now why the onus is now on the government, based on the testimony that you received, of why it's incumbent upon them to prove that when they violated your plaintiff's Section 6 mobility rights, that it was justified and warranted?
Right. So you're absolutely right. The onus is on the government, and the government is going to have to demonstrate under, as you mentioned, the Oakes test, that there's an important objective, which of course is an important objective to protecting the health and safety of Canadians. Nobody's disputing that, but it depends on how microscopic you get with respect to the objective, because if you want to look at the objective in the lens of the transportation sector, there wasn't really ever a significant threat to the health and safety of passengers in the context of transportation during the pandemic. And certainly we haven't seen any evidence of that based on the record that was produced by the Attorney General. And there needs to be a rational connection. So the measures that you have in place need to be rationally connected to the objective, and it needs to be proportionate. And the government ought to made some effort to find what's called minimal impairment, which it means, you have a series of policy options, for example, testing. Well, why is testing not acceptable? Why was mandatory vaccination required when there are other alternatives, such as testing, such as masking, that could satisfy the objective of keeping people safe in the transportation system?
Yeah, so going back to, Section 1, and so what it really comes down to is that when the government, the federal government, decided to put this travel vaccine mandate, they were using that under the auspices of the Aeronautics Act, which is where they have the legislative power in order to make decisions and rules in regarding mobility rights. And so what happened there is that within that act, there is a possibility where they could infringe on some rights if they had a safety reason. And so what's interesting is that you're saying, and it's based on the testimony you received, that the safety issue that they had and that they're claiming was not based on any scientific or medical reason, correct?
Well, I'm not even sure they understand what the safety reason was. And I say that because there's no quantification of the safety reason. I'll give you an example. When I was cross-examining individuals within Transport Canada, they testified that the vaccine helped reduce the number of, how many employees were absent because of COVID. And obviously reducing absenteeism at work is important to keeping the operations going, to keeping the airport going, keeping, railway going. And when I asked them, well, did you ever have any data in terms of how many people were absent from work prior to the vaccine, which is an important baseline level of comparison? They didn't have that data. So you can't tell me that the vaccines are miraculous and help so many people prevent COVID and avoid getting COVID if you don't even know how many people had COVID to begin with before the vaccine era. And so there was no real quantification or analysis for the risk. I mean, there was no report, for example, that says there was significant disruption in supply chain, significant disruption in flights, significant disruption in railway because people were sick, or because people didn't want to show up to work because their colleagues were not vaccinated. They had no such information. So I'm unsure how and I'm still unsure how the government came to this conclusion.
Yes, I did read a little bit of the testimony you garnered, and it seems a little strange based on the fact that they were asking for medical and scientific reasons to justify the mandate, but yet somehow they never received it. And I do really want to talk about that in more detail, but we just have to take a break. So we'll see you soon. Welcome back. Prior to the break, we were talking about some of the testimony that you garnered from the bureaucrats that you had questioned in regards to this travel vaccine mandate. And as I had read in some of the transcripts, it was interesting, some of the responses and also the time of the request, what they wanted for the information in regards to getting scientific or at least medical reasons for warranting such a mandate. Can you explain this a little bit more for our viewers?
Absolutely. So first of all, there wasn't a lot of communications that we received with respect to the rationale behind the policy. I mean, there were affidavits that contained a lot of general statements like, well, the vaccine is good and keeps people safe, therefore we should do it in the context of the transportation. There were requests that were made to the Public Health Agency of Canada to ask for documents supporting the mandate. But documents supporting the mandate are different than recommendations from the Public Health Agency of Canada to implement this mandate in the context of the transportation sector. And what emerged in the case, and I can speak about this because it is the public file, what's emerged in the case is neither Health Canada nor the Public Health Agency of Canada actually ever provided an explicit written recommendation to Transport Canada suggesting or recommending mandatory vaccination in the context of the transportation. And we did see some emails, I believe they were in October of 2021. So this is shortly before the announcement, which was announced in August, would be operationalized. So in October, they're asking for clarification on the mandate, and they're suggesting there should be one public health rationale, and they capitalized, public health rationale, P, H, and R, as though it's some sort of monolithic thing. And it's interesting to me that they were still talking about the rationale and still trying to get the messaging right on the rationale weeks before the policy was going to be implemented at the airports and at train systems. And what I'll also say is, numerous times in the media, the Minister of Transport and others were indicating to the Canadian public that this mandate was being revisited month to month or week to week or constantly under review, as they would say. And nothing in the evidentiary record suggests that. There's no emails that we see. There's no presentations that we see. Maybe they're redacted. Maybe they're withheld. I don't know. But nothing in the record indicates to us that these mandates were systematically being reviewed. And when I say that, I mean there's no independent record in front of us, no email that's being disclosed, no presentation that's being disclosed that says, well, this is what we know about the science now. Let's revisit this. Is this still a good idea?
And so just so our viewers understand, what you're telling us is that throughout this entire time when a decision was made that there's going to be a travel vaccine mandate, when this decision was made, there was no evidence or scientific or medical reason for doing that decision, for making that decision. And right up to the point where it was supposed to be, I guess, enacted or it was going to come into play, there were still government actors requesting some type of scientific and medical reason why they should have this travel mandate, but yet none could be found? Is that?
Well, this isn't me saying it. I mean, you're right. I would encourage anyone who has the time and interest to go look through the public filings. I mean, the government doesn't have any risk assessment in August of 2021 or before then that leads them to the conclusion that this is a necessary policy. And in fact, the only time we see some sort of a systematic assessment being done is in May of 2022. So shortly before they decided to revoke or suspend the mandate, whatever you want to call it, because the government is calling it a suspension. And so that's the first time you see it, which is surprising. One would have thought that such analysis was being performed prior to the decision being made.
I see. So, as you know, most businesses usually have risk teams, risk assessments, and it's usually done a lot. But what's happening here is that you found no evidence of any type of risk assessment. It just seems a decision was made, and then afterwards there was trying to find a justification, and there was none to be found either. So what it really comes down to is, did you find any evidence that says why the mandate was actually asked for? Like, what was the reason? There has to be some form of rationale, or there's no evidence to that either.
Well, I think it's political. If you recall, Prime Minister Trudeau made mandatory vaccine for travel a campaign promise. Now, why a public health measure is subject to any sort of campaign dialogue, I'm not entirely sure, but it was a campaign promise. It's public. There's several articles discussing prime ministers that discussions on not having to force someone to sit next to somebody who's not vaccinated. So again, I think a lot of the reasoning here is vaccines are good. We want to promote vaccine uptake in the population, which everyone should have the right to make their own decision with respect to whether they want to get vaccinated or not. And therefore, we should start implementing it as a policy wherever we can.
Well,
and that's precisely why they did in the transportation sector.
Welcome back. And right before the break, we were just talking about some of the reasons of why the travel vaccine mandate was made. And it seems it's possible that it could have been political. We don't know. There's not enough evidence there, but there's also no evidence to support any medical or health reason why this mandate was given. And that being said, this story was, broken out on the National Post by Ms. Subramania. And frankly, we haven't seen any other news media outlets really talk about it and pick it up. Not that this is really like your expertise, but why do you think that's the case? Because this is a very important lawsuit. It says volumes.
Well, I think some of the information that came out might have been inconvenient. And in Canada, I think generally it's true that most Canadians are trusting of their government. Excuse me. Most Canadians are trusting of their government. And to know that, very high levels of government didn't really do their homework, and yet we're more than happy to implement and maintain this policy for several months, which had a sweeping effect on approximately 6 million Canadians, might be something we don't necessarily want to confront about ourselves. But as to why more mainstream media didn't pick it up, I'd love to ask them.
Once a decision is made, do you think the story may be further reported on, or it'll again be tucked away in a corner because it's not appealing for some people?
Well, I don't have that. I don't make that decision. I hope those who do make that decision appreciate the significance and implications of this decision one way or the other. And I think that no matter what outcome we see, the evidence is still important. We should not let the judgment necessarily paint the evidence, because the evidence speaks for itself. Now, how the ultimate case might be decided is, of course, very much important and very much important to our clients. And we're all waiting to see. Hopefully it's going to get to a hearing stage where a decision will be made. But the statements that are made by the most senior government officials under oath, that's not contradicted by the decision. And those statements should be read, and those statements should be appreciated for what they are. And to the extent that Canadians feel that it falls short of what we might expect from the most senior level of government officials and very important places in the Public Health Agency of Canada and Health Canada, I think that's a conversation worth having.
I agree. I mean, the fact that there was no, health or scientific reason why these mandates were put in place is perplexing. Because the only way you can infringe upon certain rights is you have to have justifiable reason. So that being said, as you mentioned, we don't know when the decisions come. What's left in this case?
So right now we're fighting a motion from the Attorney General. They brought a motion to dismiss our application as being moot. In other words, there's no controversy anymore. There's no dispute. And they're saying that there's no dispute because, as you know, in June of 2022, the mandates were suspended. In other words, they're no longer in operation. So if you're not vaccinated, you can now travel by plane or train. We disagree. We don't think the issue is moot. We think, first and foremost, it raises very important questions about public health measures that are available to the federal government and, quite frankly, to any government. And we also don't feel it's moot because we don't know how the government is going to react in the future. As I'm sure a lot of your viewers know, these public health measures are turned on and off whenever the government believes it's appropriate to do so. So the fact that right now, temporarily, it's not in effect does not preclude the federal government from doing exactly what it's done for the better part of a year.
Agreed. And the fact that you use the term it's suspended, it didn't mean that it's been revoked. It means it's suspended, which means it could be implemented at any moment and for any reason, apparently. So at the end of the day, yes, I mean, you have a battle. It's an interesting argument on their end, and I can see why they would want to close it. But at the end of the day, a suspension means it can come back. So hopefully, you'll be successful in this motion, and we'll see what happens. After that, what's left on the table?
Yeah, if we succeed on the motion, we have a 5-day hearing that's scheduled in October. I presume it's going to be in Ottawa, but we don't yet know. And that hearing is going to be the opportunity for my clients and the other parties that have also brought a challenge to present their evidence in front of a judge. The complete evidentiary record will be there. We'll be making full arguments on the evidence. And hopefully from there, we'll be getting a decision as to the constitutionality of these mandates.
And what timeline do you think that would be?
Well, our hearing, if it does proceed, our hearing, I believe it's currently scheduled for late October. Now, when we might get a decision from the court, I don't know. But I'm hoping it would be in 2022 at some point towards the end of 2022, because it's an important issue. And I think Canadians deserve to have to have answers to a lot of the policies that were implemented and maintained.
I agree. So thank you so much for coming on the show. This was very informational. We probably will do a follow-up with you. So good luck, and we'll talk soon.
Thanks. I appreciate it. Have a great day.